Thank you very much, Ralph. I want to thank you and your predecessor, Carol Shields, and the other board members of the People for the American Way. I want to thank you for hosting this event, and I thank all of you for participating, because one of the great questions the American people will answer in this election is the future of the Supreme Court, the future of the federal courts generally, and what the shape of American life will be when it comes to the individual rights of American citizens, and potentially as important, the power of the United States Congress and the federal government to protect the American people from all manner of things in the face of a determined effort by what is already on occasion the majority in the Supreme Court to limit the ability of the Congress to do it. On a daily basis, federal judges make decisions that affect our everyday lives. Of course, they can decide at the Supreme Court level whether women continue to have the right to choose, or if their fundamental rights to privacy will be eliminated, whether the government can keep a safe environment for our children, whether we can keep guns out of schools, whether we can pass a law to protect women from violence, whether we can ban hate crimes, and whether we can expect the states to cooperate with the federal government and do their part if the Congress finds a national interest, or whether we will have a new form of ultra-conservative judicial activism that rejects the government's rights, our authority to protect the rights of our citizens and the interests of our citizens. For 8 years now, I have worked to ensure that our courts at all levels are filled with judges who are qualified, fair, reflect our nation's diversity, and uphold and enforce our laws. Since 1993, I've had the honor to appoint more women and minorities to the federal bench than any previous president, almost half of my judicial appointees. They have But I'm also gratified to know that they have garnered the highest percentages of top ABA ratings of any group of presidential appointees in nearly 40 years, which shatters the myth that you can't have diversity and excellence at the same time. In spite of the fact that study after study after study have shown how qualified these people are, and I might add, how relatively non-ideological and mainstream, a number of my appointees, especially in election years, both in 1996 and this year, although in this case some of these go back the last 3 or 4 years, have been denied a place on the bench, and in many cases even denied a hearing for partisan political reasons, even though it's clear that they're qualified. There are more than 40 pending judicial nominees currently. More than half of them are women and minorities. A study not very long ago showed that the women and minorities I appointed had to wait a whole lot longer for a hearing than guys that look like me, and that they were much more likely to be denied. For example, even though the Fourth Circuit in our country in the southeastern United States has the largest percentage of African Americans of any circuit in the United States, no African American has ever served on it. And there have been plenty of qualified lawyers in the Fourth Circuit who happen to be African American. Roger Gregory would be the first African American. He's not been given a hearing. In the Fifth Circuit, which has, next to the Ninth Circuit, the largest number of Hispanics, Enrique Moreno graduated with great distinction from Harvard and is a native of El Paso, and the judges in West Texas said he was one of the 3 best lawyers in West Texas, has been deemed unqualified for the Fifth Circuit by the Republican senators. And I might say the response from the other Republican officials in Texas has been deafening silence. The longest waiting appellate nominee is Helene White of Michigan, who has been waiting for 3 years now. They include Kathleen McCree Lewis, daughter of the civil rights line, Wade McCree. She'd be the first African-American woman to serve on the Sixth Circuit. The people who can't get a vote include Bonnie Campbell, former Attorney General of Iowa, who led our administration's efforts to pass the Violence Against Women Act. And, you know, time and again I have asked the Senate leadership just to give these folks a vote. But they did it once when they rejected Ronnie White, the first African-American state Supreme Court justice in the history of Missouri, who was turned down for a federal judgeship, though he was superbly qualified on grossly political grounds. And the reaction of the public in Missouri and throughout the United States was predictable and quite honorable. And so the next strategy was that people don't like it very much when we vote these folks down, so we'll just let them die in silence. We'll just never have hearings. And I've had, as you might imagine, a lot more success in appointing federal trial judges, but the Republican majority has been quite sensitive to the appellate courts because they know they make a lot of policy, just like the Supreme Court. And when they had the White House the last time, they appointed a lot of very young people to those appellate courts in the hope that by the time they got it the next time, whatever they couldn't pass through Congress and whatever the American people wouldn't put up with, they could just do it through the courts with people who had life tenure. Now we're just a vote or two away from reversing Roe v. Wade in the United States Supreme Court. And I think it's inevitable that the next president will have 2 appointments to the Supreme Court, could be more. And beyond that, as I intimated in my opening remarks, there has already been a majority in this court for restricting the ability of Congress, even a bipartisan majority in Congress, to get the states to help implement public interest legislation that protects people. The Supreme Court threw out part of the Brady bill because it required the states to help do things. Struck down part of the Violence Against Women Act. And other laws that I'm sure that the people that are going to be part of this forum will talk more about this, and I don't need to go through this whole litany of cases. But I can tell you that Justice Scalia and Justice Thomas, occasionally with 3 others voting with them, have a view that is quite different than the view that has prevailed in the country for the last 40 years about what Congress should be able to do to advance the cause of civil rights and the environment and public health. Now, I have no doubt this view is honestly held, and I have no personal criticism of them, but they do have a lifetime appointment and unlimited abilities, except only by the cases that come before them, to advance this view. And if they get 1 or 2 more allies and their view prevails, we'll have a philosophy of what the role of the national government in our country's life is that will be coming out of the Supreme Court, that will have as its only modern parallel what prevailed in the 1930s, until Franklin Roosevelt tried to pack the court with the help of his majority leader from my home state, Joe T. Robinson. And the public hated it, and there was a terrible reaction. But afterward, the Supreme Court began to uphold the New Deal legislation. And so we all want to pretend that there's no politics in this, but there is certainly philosophy in this. There is philosophy in the appointments of Supreme Court justices and appellate court justices. And therefore, the presidency is important, but the Senate races are important as well because they have to confirm these folks.